Statement, the Lord Chancellor and Secretary of State for Justice, Mr. Kenneth Clarke.
Thanks, Lord. Mr. Speaker, with permission, I wish to announce today proposals for the reform of legal aid in England and Wales and proposals for the reform of civil litigation funding and costs in England and Wales. I have today laid before Parliament two documents, one called Proposals for the Reform of Legal Aid in England and Wales, and the other Proposals for the Reform of Civil Litigation Funding and Costs in England and Wales, which consult on these issues and of which copies will be available in the Vote Office and on the Ministry of Justice's website. The changes will require primary legislation, and subject to consultation, I hope to include proposals in a bill as soon as parliamentary time allows. And I would like to apologise to the House, Mr. Speaker, for the well-informed, though not wholly accurate, leaks which appeared in the newspapers at the weekend of my proposals, which caused me to bring forward this statement. I was hoping to abide by the convention of announcing this to Parliament, but it was obviously going to run for the week if I left it till Thursday to make the announcement. So, Mr. Speaker, legal aid forms a vital part of a system of justice of which we are rightly proud. The Government strongly believes that access to justice is a hallmark of a civilised society. However, I believe that now there is a compelling case for going back to first principles in reforming legal aid. The current system bears very little resemblance to the one that was introduced in 1949. Legal aid has expanded so much so that it's now one of the most expensive in the world, costing the public purse more than £2 billion each year. It's now available for a very wide range of issues, including some issues which do not require any legal expertise to resolve. It cannot be right that the taxpayer is footing the bill for unnecessary court cases which would never even have reached the courtroom door were it not for the fact that somebody else was paying. The previous government made many attempts to reform legal aid, conducting over 30 consultations on the subject since 2006. However, successive changes have been of a piecemeal nature and have failed to address the underlying problems. I have gone back to basic principles to make choices about which issues are of sufficient priority to justify the use of public funds, subject to people's means and the merits of the case. I have taken into account the importance of the issue at stake, the litigants' ability to present their own case, the availability of alternative sources of funding and of alternative routes to resolving the issue, as well as our domestic and international legal obligations. My proposals have also been designed with the aim of achieving significant savings. No other government in the world believes that the taxpayer should pay for so much legal aid and litigation as we do in the United Kingdom. We have made clear our commitment to reducing the fiscal deficit in order to encourage economic recovery. Last month's spending review set out the scale of the challenge. My department's budget will be reduced by 23% over 4 years. Legal aid needs to make a substantial contribution to that reduction. I estimate that the proposals in the consultation paper, if implemented, will achieve savings in the region of £350 million in 2014 to 2015. I do not propose any changes to the scope of criminal legal aid. However, I propose to introduce a more targeted civil and family scheme which will discourage people from resorting to lawyers whenever they face a problem and instead encourage them to consider more suitable methods of dispute resolution. Legal aid will still routinely be available in civil and family cases where people's life or liberty is at stake, or where they're at risk of serious physical harm or immediate loss of their home. So, for example, I plan to retain legal aid for asylum cases, for debt and housing matters where someone's home is at immediate risk, and for mental health cases. It will still be provided where people face intervention from the state in their family affairs, which may result in their children being taken into care, and for cases involving domestic violence or forced marriage. I also propose that legal aid should remain available for cases where people seek to hold the state to account by judicial review, and for some cases involving discrimination which are currently in scope. Legal assistance to bereaved families in inquests, including deaths of active service personnel, will also remain in scope. However, prioritising these areas requires that we make clear choices about the availability of legal aid in other areas. Therefore, we propose to remove from the scope of the scheme issues which are not, generally speaking, of sufficient priority to justify funding at the taxpayer's expense. I therefore propose to remove private family law cases unless there is domestic violence, forced marriage or child abduction involved. I will continue to provide funding for mediation, which can benefit those involved in family disputes by avoiding long, drawn-out and acrimonious court proceedings. Other cases which I am proposing to remove from the scope of the civil legal aid scheme include clinical negligence, where in many cases alternative sources of funding are available, such as no-win, no-fee arrangements. They also include the cases I'm proposing to remove from scope: education, employment, immigration, some debt and housing issues, and welfare benefits, except where there is a risk to anyone's safety or liberty or a risk of homelessness. In many of these, the issues are not necessarily of a legal nature, but require other forms of expert advice to resolve. I do recognise that there will be some cases within those areas of law which I propose to remove from scope, which international or domestic law will require to be funded by the taxpayer. I therefore propose a new exceptional funding scheme for excluded cases. I want to ensure that those who can pay for or contribute to their legal costs do so, so that we ensure continued access to public funding in those cases that really require it for those who have little or no funds of their own. On eligibility, therefore, I propose that all clients with £1,000 or more of disposable capital should make a minimum £100 contribution to their legal costs, and that the capital of any prospective legal aid clients is taken into account when considering eligibility. I've also looked at how best to reform the way in which we pay lawyers who provide legal aid services. I want to ensure that criminal cases are resolved quickly and cost-effectively, and that legal aid fee structures support that aim. In the long term, I propose to fulfil the noble Lord Carter of Cole's recommendation to the previous administration to move towards a competitive market to replace the current system of administratively set fee rates. However, it will not be possible to fulfil that aim in the short term. Therefore, I am proposing some more immediate changes to the current fee structure. I propose to ensure that in Crown Court cases that could realistically have been dealt with in the Magistrates' Court, a single fixed fee for a guilty plea will be paid based on fee rates in the Magistrates' Court. I also propose that the same fee should be paid in respect of a guilty plea in the Crown Court, regardless of the stage at which the plea is entered, and to do more to contain the costs of very high-cost criminal cases. These proposals complement other reforms to the justice system which I will be bringing forward, designed to encourage cases to be brought quickly and efficiently to justice, so sparing the victim the ordeal of giving evidence in court unnecessarily and sparing the justice system significant but avoidable costs. It's important to strike a balance between the need to ensure that legal aid provision is innovative, efficient and good value for taxpayers' money on the one hand, and ensuring that people can continue to access legally aided services where necessary on the other. I believe there's more that can be done to strike the balance. I propose to reduce fees paid in civil and family cases by 10% across the board and make similar levels of reductions in rising expert fees. I also propose to extend telephone access to advice through the Community Legal Advice Telephone Helpline, which has a high rate of public satisfaction, to help people find the easiest and most effective way to resolve problems. I'm also consulting on proposals to make better use of alternative sources of funding for legal aid. In particular, I would welcome views on making use of the higher rates of interest generated on money invested in a pooled account used by solicitors to hold their clients' money, and on making use of a supplementary legal aid scheme. Lastly, I seek views on how to make the administration of legal aid less bureaucratic for solicitors and barristers doing legal aid work. I recognise that processes have become overly complex and want to do what I can to simplify these while remaining consistent with the highest standards of accounting practice. Now also, Mr Speaker, on the 26th of July this year, the Government announced its intention to consult on implementing Lord Justice Jackson's recommendations on the reform of civil litigation costs and funding arrangements. Sir Rupert Jackson's independent and comprehensive report, published in January 2010, makes a clear case that the costs in civil cases in England and Wales have become too high, and he makes a broad range of recommendations for reducing those costs. I am convinced by Sir Rupert's argument that achieving proportionate costs and promoting access to justice go hand in hand. I believe that the consultation proposals for the reform of civil litigation funding and costs presented today would help rebalance access to justice with proportionate costs in civil cases. In particular, Sir Rupert's proposals reform the operation of no-win, no-fee conditional fee arrangements, known as CFAs. CFAs are funding agreements under which lawyers are not paid if they lose, but they may charge an uplift of a success fee of up to 100% on their base costs if they win. CFAs, as they currently operate, allow claims to be brought at no financial risk to individual claimants, but the other side of that coin is that CFAs impose substantial additional costs on defendants. The Government's already accepted the recommendations of my right honourable and noble friend Lord Young of Grafham's recent report on health and safety and the compensation culture. It's entitled Common Sense, Common Safety. My noble friend's typically cogent report endorses Sir Rupert's proposals. The key proposal is to abolish the recoverability of these high success fees and the associated after-the-event insurance premiums in CFA cases. Under the current regime, defendants must pay these additional costs if they lose, and these additional costs can be substantial, as a success fee can be double the base legal costs. In addition, significant costs can arise from claimants' purchase of after-the-event insurance, known as ATE insurance. That can be taken out by parties in one of these cases to insure against the risk of having to pay their opponents' costs and their own disbursements if they lose. We're proposing that claimants should have to pay their lawyer's success fee, and they will therefore take an interest in controlling the costs being incurred on their behalf. This will also reduce the disproportionate cost burdens on defendants. We're also seeking views on implementing other recommendations by Sir Rupert which are designed to balance the impact of these major changes, in particular to assist claimants. These recommendations include a 10% increase in general damages to help the claimant pay the success fee, and introducing a mechanism of qualified one-way cost shifting. This would protect the vast majority of less well-off claimants from paying a winning defendant's costs and will therefore reduce the need for after-the-event insurance. We also propose to allow damages-based agreements or contingency fees in litigation before the courts. These are another form of no-win, no-fees agreement under which lawyers can take a proportion of the claimant's damages in fees. This would increase the funding options available to claimants. Other proposals would further encourage parties to make and accept reasonable offers, as well as introducing a new test to ensure that overall costs are proportionate. We also propose to increase the modest costs which can be recovered by people who win their cases where they represent themselves without lawyers.